Definition of terms. Pardon is a form of executive clemency granted by the President of the Philippines as a privilege extended to a convict as a discretionary act of grace. Amnesty is a special form of pardon exercised by the President more on political offenders, for example, the NPA or communist group in the Philippines. Probation is a disposition under which the defendant, after conviction and sentence, is released to the probation of a probation officer subject to the conditions imposed by the court. Parole is a temporarily releasing a criminal for a special purpose or permanently before the completion of his or her sentence due to promising good character. Reprieve is a deferment of the implementation if the sentence for an interval of time it does not annul the sentence but merely postpones or suspends its execution. Commutation of sentence is a reduction of the duration of a prison sentence of a prisoner. Carpeta is the institutional records of an inmate that consist of his commitment order or mitimus. Absolute pardon, it is refers to the total extension of criminal liability of the individual to whom it is granted without any conditions attached or whatsoever. It restores the individual his civil rights and remits the penalty imposed for the particular offense of which he/she was convicted. Conditional pardon, it is the exemption of an individual within certain limits or conditions from the punishment that the law inflicts for the offense he/she has committed. Person record, it is the personal circumstances of the inmate. It contains the fingerprint, signature, mugshot, or any violation while inside the Constitution. The enumeration, the three major problems of the correction are the prison congestion, prison overcrowding, and the inadequacy of training programs for personnel in the institutional and non-institutional correction. The purpose of absolute pardon is to right a wrong or to correct a wrong, to normalize tumultuous political situation, and to restore the individual's civil political rights. Disqualified offenders for probation. First is once placed on probation. Second is already serving sentence at the time the substantive provisions of probation's law became applicable. Third is sentenced to serve a maximum sentence of imprisonment of more than 6 years. Fourth is convicted of subversion or any crimes against national security of the state and public order. And the fifth is previously convicted by final judgment and punished by imprisonment of not less than 1 day or fine of not less than 200 pesos. Disqualified offenders for parole. First is those convicted of piracy. Second is those who are habitual delinquents. Third is those who have escaped from confinement or evaded sentence. Fourth is those whose maximum term of imprisonment does not exceed 1 year. Fifth is those who, having been granted conditional pardon by the chief executive, shall violated the term thereof. Sixth is those convictions is on appeal or has not yet become final and executory. Seventh is those already sentenced by final judgment at the time of approval of this act except as provided in Section 5 hereof. 8 is those convicted of misprision of treason, rebellion, sedition, or espionage. 9 is convicted with death penalty or reclusion perpetua or life imprisonment. And 10 is convicted with treason, conspiracy, or proposal to commit treason or espionage. Conditions of probation. First is cooperate with a programs of supervision. Second, meet his family responsibilities. Third is refrain from visiting houses of ill repute. Fourth is pursue a prescribed secular study or vocational training. Fifth is abstain from drinking and intoxicating beverages to excess. Sixth is devote himself to specific employment and not to change said employment without the prior written approval of the probation officer. Seventh is undergo medical psychology or psychiatric examination and treatment and remain in a specified institution when required for that purpose. 8 is attention or reside in a facility established for instruction, recreation, or residence of persons on probation. 9 is present himself to the probation officer designated to undertake his operations at such place as may be specified in the order within 72 hours receipt of said order, and 10th is report to the probation officer at least once a month at such time and place as specified by said officer. The discussion. First question is a difference between parole and probation. The parole is an executive function and must serve the part of sentence in prison before release. It is an institutional treatment that is granted by board with conditions and subject to supervisions of the parole or probation officer, while probation is a judicial function of the government which offender does not need to go prison. It is a substitute for imprisonment that is granted by judge with conditions and subject to supervision of the parole or probation officer. The second question is difference from absolute and conditional pardon. A absolute pardon which totally extinguishes criminal liability of an individual without any conditions, while conditional pardon which exempts an individual with certain limits or conditions from punishment his or her crime committed, resulting in the partial extension of his or her criminal liability. And the third question is discuss the advantage of probation. A probation has several advantages to incarceration, including the ability to work in the community, earn money to support one's family while attending counseling sessions. Probation costs the state a fraction of the cost of a jail or prison sentence. Natin.